So good morning, I'm Leonardo McClarty, and I'm the president of the Howard County Chamber, and I'd like to welcome you to our first GovConnects Scale Up Series webinar of the 2022 year. And so certainly excited to get things off and started. And I think we've got a extremely timely presentation that is scheduled today as we continue to deal with everything that's related to COVID-19 and how it's still impacting us both personally and professionally. And for those that are in the government contracting realm and even private employers, certainly continue to have to deal with various mandates, whether that is federal or even in some instances, even state and local jurisdictions. And so certainly excited to have Sarah Nash here with us with PilieroMazza, who will be sharing her insights and experience as to what many of you need to know and need to expect, or perhaps should expect in the days ahead. And so, again, we are extremely excited to have her and thank PilieroMazza for their continued support of the Chamber and that they're one of our that truly support the Chamber. And actually you see them on the virtual background behind me. And so one of the things I do want to do is recognize our 2022 GovConnects sponsors led by Tower Federal Credit Union and also Katz Abosh, and then also followed by Reliant Management Corp, Aronson, and then Edwards Performance Solutions, Uninet, BDO, and BTS. And so again, we're thankful for them. And then, as I mentioned, PilieroMazza is one of our sponsors for specifically the Scale Up series. And so there's still opportunities to be an annual partner for the 2022 year. If there's interest, certainly you can reach out to me and I can share all of the benefits and the various levels that would be available to you. And so the other thing before we get started, I do want to, I'm going to actually share my screen for just a moment, is I want to just bring to your attention a few upcoming events on the Chamber side that's specific to GovConnects. And so the first one coming up is actually going to be on the 10th of February. And we're going to have Aberdeen Proving Ground and Kenyatta Wesley, who's the executive director of the Army Contracting Command. And many of you will probably remember it's been, I think now maybe about 3 years or so since we've had APG, but Kenyatta is highly informative and someone that doesn't mince words, and you will certainly leave with a lot of keen insights. And so certainly encourage you to get registered for that on February 10th. Also coming up as well as our Ask the Experts. And so while this is more on the, I guess, the commercial non-GovCon side of the house, I think the topic is germane to anyone that's currently running a business at the moment. And it's solving the labor force dilemma and looking at alternative recruitment strategies. And so I think we've got a very diverse panel here that runs from public sector to obviously private sector to academia, as well as to even as we look at people that might be differently able. And so again, that's going to be on the 9th. And then on a much lighter note, every year the Chamber takes a trip abroad that we offer, and it's strictly leisure. And past couple of years, we've had to put it on the shelf due to COVID, but we think we're back and we'll be able to have some folks go abroad. And so if you're interested in going to the French Riviera, there's an information session coming up on the 15th. Also, you can see Lynn's information there at the bottom. Lastly, our State of Business Address. This is something we've been doing now for about, I think this is probably around 14, 15 years with the Howard County Executive's Office. We've now spanned, I think, 4 county executives. And so excited to have Dr. Calvin Ball join us on the 23rd. And so details will be on our website, particularly as it relates to some of the safety protocols. We'll be doing this event a little bit differently than in years past, but certainly it will be live and in person. So for those of you that do not want to attend a virtual event, no worries. This will be an in-person event. I will tell you that masks will be required, but certainly we'll always have great opportunity for networking and so forth. And it's a little bit earlier time. And so details are forthcoming on the state of business. And so with that, we will get ready to turn things over to Sarah. And just to share a little bit about Sarah Nash, our speaker this morning. She is, again, an attorney and partner with PilieroMazza and advises government contractors and commercial businesses on a wide variety of labor and employment issues, including the Fair Labor Standards Act, the National Labor Relations Act, the Office of Federal Contract Compliance Program Regulations, and anti-discrimination law. She ultimately, when you get a chance to read her background, she deals with everything related to employment, labor, prevailing wage, compliance with government contractors, ethics issues, but ultimately, if it deals with your people in your office, she probably can handle it in some form or fashion. She is the co-chair of PilieroMazza's False Claims Act and Audits and Investigations team, and again, helps clients navigate the complexities of labor and employment-related investigations and whistleblower law. And she's also a member of the firm's construction industry team as well, where she focuses on Davis-Bacon-related efforts there. Stanford grad and a law degree from George Mason University School of Law. And so with that, I'm going to now turn things over to Sarah to get things started here. And so, Sarah, as we like to say, the screen is yours.
Thank you, Leonardo. And I'm going to revise my bio to just say, if it deals with your people, we handle it. So I think that's great and concise. So thank you, everyone, for joining on this Tuesday morning, especially to talk about something that I'm sure we are all over talking about. Leonardo mentioned earlier that we're all ready to get back into in-person events, get rid of this virtual meetings. And so hopefully that is on the horizon. But if you will bear with me for the next 45 minutes or so, we can talk a little bit about some of the updates in the world of COVID-19 vaccine mandates and what they mean for government contractors. And we'll touch a little bit on what they mean for private employers as well. As many of you may know, recently the Supreme Court issued or reissued an injunction on that OSHA ETS for employers with 100 or more employees. And so for the time being, there are not many restrictions on private employers. That said, nothing requires companies to get rid of their vaccine mandates. So we'll talk a little bit about how to have a legally compliant vaccine mandate and what some considerations are as you navigate sort of that prickly world of ADA and Title VII and all of the state specific laws that are out there as well. So let me just, oh, perfect. We've already heard more than enough about me. And PilieroMazza, we are a business law firm. We have labor and employment as a practice, but we also have a government contracts practice, a litigation practice, and a business and transaction practice. Those are our main sort of areas of focus. And then within that, we often work with government contractors, Native American law, and nonprofits. And we just have a broad range of clients that we support. So hopefully, no matter where you're from today, especially I can touch on some useful tidbits about vaccine mandates that you can take back to either your folks or your clients, whoever they may be. So we're going to focus on, for the first part of this, some of the Biden administration actions that have taken place, because there have been quite a few, and it's hard often to keep track of what's been stayed, what's going on, like what's still out there, what's in effect, and how they interact with each other. Because I think there's 4 total federal mandates that really can overlap, and it's not entirely clear what's still in effect and what isn't. So we'll be sure to go over that, and everyone will have a clear understanding of what applies to them, hopefully by the end of this, and where it stands legally. We'll also talk about where those court decisions are, whether they are permanent, whether they are temporary, and to the extent we can read the tea leaves a little bit about what we anticipate for final outcomes on those different tests. And then we're also going to talk about accommodations. You can't talk about vaccine mandates without talking about accommodation exemptions, specifically ADA exemptions and sincerely held religious belief accommodations. So we'll touch on those. They can be sort of a headache to deal with if you're looking at them for your own company, but hopefully I can give you some tips for how to make them a little bit less mysterious. We'll also talk about state laws. As I mentioned, a number of states are legislating on vaccine mandates. The vast majority are issuing, not the vast majority of states, but the states who have legislated on this issue are, for the most part, limiting companies' ability to enter into mandatory vaccination policies. There are some cities and localities, however, who have taken the other approach and required vaccine mandates. So we'll try to distinguish between those different approaches on a state level, and then just some other considerations that we'll go through as we touch on these issues. So one of the first Biden administrative actions that's still in place and that impacts government contractors is in July 2021, the Biden administration established the Safer Federal Workforce Task Force. It is a mouthful. Smarter, more clever people than I have pointed out that it has a WTF in it. So it is not the most aptly named task force, but it does govern a lot of the requirements for government contractors as related to sort of COVID safety protocols. Eventually, or previously, we have to see what the courts do, COVID vaccine mandates and testing for accessing agencies. And so back in July, which feels like forever ago at this point, the task force issued model safety principles for agencies. And it's important to note that this particular realm of requirements has not been impacted by any of those state decisions out there. So these are still in effect. I often receive questions from clients questioning whether an agency can require testing of their unvaccinated employees in light of the ongoing court cases out there and in light of the stay on the greater federal contractor vaccine mandate. And my response is, yes, agencies can continue to issue worksite access restrictions. In fact, for the most part, the administration is encouraging them to do so. And so it is not unlikely to see agencies issuing requirements for if your people are going to be coming on the work site. Generally, if that's the case, and it's not all agencies at this point, it's not all facilities. And in fact, last week, 2 weeks from now, the administration is going to require all federal employees coming onto the work site to show a negative test if they're unvaccinated. However, that blanket rule doesn't apply to contractors yet. And so it's going to be agency by agency wide. My guess is if agencies start and facilities start implementing these requirements, they're going to apply it to contractors as well, just because once they have the policy in place, why not apply it to everyone who's coming in the door, but we'll wait and see. So the really takeaway point on this is that a lot of agencies are going to be requiring their unvaccinated employees to show proof of a negative test either within 72 hours or a week of accessing the work site. As a lot of you may know, given the Omicron surge, it's not easy to get tests right now. And a lot of questions that we're receiving from folks relate to whether they are required to pay for these tests. Unfortunately, the DOL has not issued really clear guidance on whether testing must be paid for by employers, where employees are required to undergo the testing. This is something that if I had to guess, ultimately they would place the cost on companies. But again, there's no clear guidelines. Some states have come out and said, yes, absolutely, you are required to pay for the testing. You can probably guess which states those are. California is top of the list. They issued guidance fairly early on saying that if you're requiring your employees to get tested, the companies must not only pay for that cost of the test, but also pay for the time that it takes the employee to get tested. So that's going to apply to your non-exempt employees, because those are the ones who are paid on an hourly basis. Salaried folks, not as much a concern because they're paid a salary regardless of the hours worked in the week. So if you have fully vaccinated employees who are going on site, generally they have to confirm that they are vaccinated and wear a mask in most areas where there's higher substantial transmission rates. This is evolving a little bit with the CDC guidance, but generally the guidance is still saying wear masks in most localities, and those individuals are not restricted from travel. Individuals who are unvaccinated do have to go through that weekly and biweekly COVID testing. They must wear a mask and socially distance, and they are subject to restrictions on official travel. As everyone probably is aware, there is a mandate for federal employees as well. However, just as it applies to contractors, federal employees also must be granted exemptions for medical or religious belief reasons. And so in those instances where federal employees have been granted an accommodation, they are subject to those same unvaccinated requirements if they're accessing the work site. So in September, Biden issued 3 specific mandates that apply not just to government contractors, but to the broader private workforce. And so one of those requirements is Executive Order 14042, which if you're a government contractor, you're probably very familiar with by now. That is a requirement that has been currently stayed. I'll talk a little bit about how that stay is operating in the timelines there. But until it was stayed, it required vaccinations for federal contractors and ongoing safety protocols. There is also a vaccine mandate that was issued under an OSHA ETS, that's an emergency testing standard, temporary standard, excuse me. And employees with more than 100 employees were going to be subject to this requirement. This was recently stayed by the Supreme Court. It's not the final ruling on this matter, but it probably means that if it be before the Supreme Court in the future, the ETS would be struck down. So it's unlikely that we'll be seeing a vaccine mandate for private companies with those 100+ employees. There was also, as a part of that, a requirement for paid leave to get employees vaccinated. That has also been stayed in light of the Supreme Court's decision. And then lastly, there is a requirement for vaccinations of healthcare workers at Medicare and Medicaid hospitals and healthcare settings. This was also recently reviewed by the Supreme Court and found to be a lawful ETS. And so that healthcare vaccine mandate is still in effect. The Supreme Court has been getting a little bit of flack for the differing opinions compared to private employers with 100 employees versus the healthcare settings. I'll talk a little bit about why they might have come down the way they did. So first, I'll touch on the vaccine mandate for federal contractors. And this is unfortunately something that I do not have a lot of insight into where it will end up, but I can talk about where it's been. So the District Court of Georgia, Southern District, stayed the vaccine mandate back in December 7th. This is actually not the first court that has stayed the vaccine mandate, but it is the first court to stay it on a nationwide level. In November, just a week previously, a Kentucky district court had granted a preliminary injunction that was limited to Kentucky, Tennessee, and Ohio. Shortly thereafter, this Georgia district court granted the nationwide preliminary injunction. I'm not going to get into the legal boring details about why one court issued it nationwide and the other issued it just to 3 states. Feel free to reach out to me if you really are curious about that legal sort of inner working. But for all intents and purposes, for this time being, the executive order has been stayed. Generally, the court found that the Biden administration, Biden, had exceeded their administrative abilities to sort of regulate procurement agencies. And so that's what the court decision found. It is currently pending before the 11th Circuit. What we have been telling clients, what I've been telling clients is, for the time being, we do not know if the vaccine mandate for federal contractors will be lifted in the future. This means that at any time, the stay could be lifted, which would mean that the law is back in effect, and we do not have a great insight into how agencies will handle this. Our hope is that the Biden administration will issue kind of a sweeping guidance about how the stay will be implemented and how agencies will begin to start reinforcing the executive order. But we just don't know. So it could be one day the court lifts the stay, if that's in the cards, and the next day the government starts enforcing it. To that end, we've been encouraging folks, to the extent that it doesn't create too much hardship, to continue to enforce their vaccine mandates. There is one caveat, though. If you are operating in a state, and there are many, that has a restriction or a prohibition on vaccine mandates for your employees, it might not be worth the risk at this point. So I'll talk a little bit about what those restrictions are. There is an expedited appeal of the Georgia decision that is before the 11th Circuit. They actually just yesterday submitted final briefings on the issue. So I'm hopeful that we will hear in the next couple of weeks what the outcome is, and hopefully give everyone a little bit more certainty in evaluating whether they will need to be, enforcing vaccine mandates. And I'll talk a little bit about what those requirements under the vaccine mandate are. As I mentioned, those worksite access and vaccination requirements and testing standards are still enforceable if your folks are going on site, because that is not a contractual requirement. That is a worksite access requirement, which is unfortunately separate. So the executive order for government contractors has some requirements that don't necessarily make the most sense in the world. For example, it is applied to any contracts where it's been incorporated, the FAR provision or the DFARS provision, if you're working on DoD work, has been incorporated into your contract. So that's the first thing to keep in mind. If it's in your contract, it's applicable. Generally, and agencies are encouraged to incorporate the vaccine mandate broadly. This means that even if you don't have a services contract, if you have a products contract, or if you have some of those other types of procurement related contracts that don't necessarily fall within services, you could still see it in there. So it's really important to gauge whether the modification has incorporated either of these two provisions into your contract. Technically, agencies are required to incorporate these clauses in new, renewed, and extended contracts. That said, as many of you might have seen back in October, November, December, agencies were issuing these regardless of whether there was a new option or a new contract. They were just sort of issuing them as a matter of course. Not all agencies, but many of them just took a sort of shotgun approach. Given the district court's decision, agencies have stopped incorporating these into contracts. Arguably, the agency's decision does not, or the district court's decision does not require agencies to stop incorporating these provisions. It just stops them from enforcing the provisions. That said, it seems to be a somewhat coordinated strategy just to wait and see what the courts say. The initial deadline was actually back in December. They kicked that back to January 18th to give everyone a little bit more lead time, but then the stay was issued. And so we're waiting to see whether it will be lifted in the future. Who is covered? Anyone, this is sort of worth, in the event that it does get stayed and stayed in the future, or lifted, and if the stay does get, that's a mouthful, if the stay does get lifted in the future, there are really 3 groups of employees that the stay will apply to. And it's important to note that it does not apply to all federal contractor employees. It really just applies to these 3 groups, which is broad. I'll give it, it's broad, but it's not everyone. First of all, it's going to be anyone working on a contract. So anyone who's working on under that PWS in your contract, including remote workers, is going to be covered by the vaccine mandate. It's also going to address anyone who's working in connection with the contract. So that's your overhead folks, maybe HR folks, people who are necessary to completing that work are considered to be in connection with that contract. And so they also must be covered by the mandate. And then lastly, anyone who's working alongside, i.e. in the same facility as those 2 previous groups, is going to be covered by the requirements. It's important to note that an attestation is not acceptable in the executive orders for federal contractors requirements. You must collect vaccine cards. And I'll note how there are a couple states out there have specifically outlawed the collection of vaccine cards. So there's a really interesting interplay between this federal mandate and the state laws. And generally my response is state laws are preempted by federal laws. It's as simple as that. That's what our Constitution is based on. Unfortunately, it's not that clear here, so I'll go into a little bit of those details when I talk about state requirements as well. You are required to flow down any executive order requirements to your subcontracts if they're covered subcontractors, however, not for vendors. And so generally a vendor is going to be distinguished from a subcontractor. Subcontractors are working on that PWS, vendors are not. That's a good way to sort of draw lines in the sand. And then finally, the requirements do implement a requirement to put in a workplace safety coordinator. This requirement has also been stayed in light of the Georgia decision. The coordinator really, it's a great idea because you need someone who's going to be monitoring the collection of these vaccine cards and accommodation requests and all of this information, but there's also a requirement that they are monitoring transmission rates to determine whether there are social distancing and masking requirements, not just for your unvaccinated folks, but for your vaccinated folks. One of the big question marks out there has been what happens if contractors do not comply with 14042? If the stay is lifted in the future, there could be some pretty terrible consequences. So for example, agencies, as you know, kind of have ability to enforce their contracts. So if for some reason a CO has determined that you are not compliant with the executive order, or you're not taking steps to comply with the executive order, they could have reason to cancel your contract. They could have reason to give you a negative CPAR in the future. They have a lot of different mechanisms to make life difficult. The next question is how are they going to know, right? How are they going to know if you collected all of your employees' vaccination cards, if you have given reasonable accommodations? Generally, what we anticipate is that most of the complaints arising out of this would come from whistleblowers. And so other employees who are unhappy about the way that contractors are implementing these requirements. Again, this is all sort of up in the air. We have to see if the stay is lifted, but there are some pretty big risks to not complying. The guidance that has been issued does indicate that if companies are making a good faith effort to comply and to get their folks vaccinated or to review accommodation requests, then agencies should, for the most part, keep an open mind. So the next, shifting a little bit, the next type of vaccine mandate was that OSHA ETS, Emergency Temporary Standard. The Supreme Court has stayed this requirement. The OSHA ETS was different from the executive order for federal contractors in that it offered companies an option. Employees need not get the vaccine if they were subjected to weekly testing. So this is a shot or test rule. Again, it has been stayed in light of the Supreme Court's decision from 2 weeks ago. That said, the Supreme Court's decision is not the final end-all decision. This was just evaluating the temporary preliminary injunction. The Sixth Circuit is still reviewing the complete case. It's possible that the Sixth Circuit will find that an injunction is not appropriate. That said, if they do issue that opinion, chances are it'll end up before the Supreme Court again. The Supreme Court made pretty clear that this type of how do I want to describe it? This type of mechanism for controlling vaccine requirements is not appropriate in their eyes. They see OSHA as a workplace safety issue, and to their minds, the COVID pandemic is not specific to workplace requirements, and so it was outside of the scope of OSHA to issue the ETS. This is a good place to mention how the Supreme Court sort of saw a differentiation between the OSHA ETS for large employers and the one for healthcare workers. Generally, in the healthcare worker sense, the Supreme Court said, we understand why this is tied to a workplace safety hazard. These individuals are specifically around sick individuals, people with COVID, and we need to be able to protect their jobs. And so that was a little bit of this distinction between the large employer ETS and the healthcare ETS. OSHA has issued a statement saying that regardless of the outcome of these proceedings, they intend to do everything in OSHA's existing authority to hold businesses accountable for protecting workers, including under the COVID National Emphasis Program and the General Duty Clause. Essentially what this means is OSHA is still out there if they have reason to believe that a company is not implementing reasonable COVID safety protocols, i.e. making sure that employees are not coming in sick with COVID, or at least not requiring them to, having a policy in place that confirms that employees who are experiencing COVID symptoms or have a positive COVID test do not come in for a specific period of time, ensuring masking where appropriate. These are the sort of things that OSHA will be looking to as they evaluate whether workplaces have perhaps subjected to employees to unsafe conditions. There's a general duty clause with OSHA that basically says that you have an obligation to give employees a workplace free from hazards. COVID is considered a hazard, and so it's important. Just because the OSHA ETS has been stayed does not mean that employer obligations in this pandemic have dissipated. A lot of states out there still have leave policies as well related to COVID symptoms. So it's just important to be aware of your local requirements as you navigate the vaccine mandate or the vaccine pandemic kind of quagmire. Again, the OSHA ETS has been stayed. I'm not going to go into all of the details about the OSHA ETS because frankly, I don't think it's coming back, but it is important to note that just because you're a federal contractor did not necessarily give you a free pass from the OSHA ETS. There was a little bit of overlap. If you have employees who are not working on work sites that are covered by the executive order, those were, assuming that you met the employee threshold, going to be covered by OSHA. But again, we don't have to worry about this because it's been stayed. Just a little bit about the history of vaccination in the employer context. I will note that prior to the COVID pandemic, you would often see that employers may implement requirements for their workforce. A good example is the flu vaccine. Often in healthcare settings, you see such scenarios where employees are required to get a vaccine in order to protect their other employees or protect patients or vulnerable populations that they're working with. So this is not really a new idea. That said, we've never seen it on this scale, and we've really never seen the level of opposition to these vaccinations. So we're getting a lot of first-time questions answered, and a lot of this is going to apply to that accommodation question, whether you're obligated to accommodate employees who claim that they have a sincerely held religious belief or who may have a medical disability. There's not a lot of case law on how these questions are going to shake out in the end, but there is some precedent for it. The EEOC has come out and said that COVID-19 poses a direct threat to the health of the workplace. That means that companies are really getting away with a little bit more than they might in a traditional non-pandemic situation. Because COVID is a direct threat, companies are permitted to ask about folks' COVID status to ensure that they are protecting the workplace. Generally, if you're familiar with those human resources restrictions on asking about employees' medical conditions, there are some really big no-nos that you don't want to step in, but because COVID is a direct threat, some of those stricter prohibitions have been relaxed for the time being. So I've touched on the fact that there are some additional considerations that might limit companies in how they implement vaccine policies. And I will note that just because the OSHA ETS has been stayed and just because the executive order has been stayed does not mean that companies have decided to, across the board, pause their vaccination policies. Some have not. And so you've probably seen the news headlines. A lot of the big companies out there, some of them are still charging forward with vaccine mandates because they've decided that that is in their business interest, whether it's from preventing employees from getting sick or whatever reasons that companies have for wanting to implement these policies. There are some different ways to do these vaccine mandates. One option is to have a vaccine mandate that applies to your workforce and says you must get vaccinated unless you have an exemption for either a medical accommodation or a religious accommodation. And those are required under federal law, under Title VII and the ADA. You are obligated as a company, assuming that you're covered by those fairly low employee threshold. 15 employees generally will do the trick. And if you have less than that, you're generally going to be covered by the state law equivalent. But shy of providing those exemptions, there's nothing that prohibits employees from implementing a vaccine mandate unless you're in one of those states that I'll talk about shortly. There's also an alternative option that sort of mirrors the OSHA ETS, this idea of you can require employees to get vaccinated or agree to weekly testing or biweekly testing. The testing question, as I mentioned, is sort of up in the air right now because we don't know who is required to pay for those tests and pay for the time it takes to get those tests. As you've probably noticed, the Biden administration is going out of their way to create a lot of access to take-home tests. So this might facilitate testing in the future. I don't know if it's a long-term solution though. And so if you are going to decide to have one of those vax or test mandates, it's important to understand how you're going to require employees to get tested. Are they going to be subject to a PCR test? Are they going to be subject to an antigen test? Can they do this at home? Do they need to do it at the office? These are kind of questions you want to make sure you've understood. A lot of companies I've seen are also starting to implement booster shot requirements. This idea of when are you fully vaccinated? Is it enough just to get the 2 first shots, or should companies be considering this booster shot as well? And then finally, testing, just figuring out how you're going to be implementing those issues. Even if you're not having a vax or test mandate, if you have a vaccine mandate, chances are you will be giving some exemptions, and for those exemptions, are you going to require employees to get tested? Again, if you're a federal contractor and your agency worksite is requiring testing as a way to gain access for unvaccinated employees, you don't really have a choice there. You need to comply with those worksite access requirements. Next, I'll talk a little bit about the different accommodations. There are 2 of them. I just want to keep an eye on time too. Okay, we're good. Accommodations for ADA disabilities. This is probably the more in labor and employment world, the world of labor and employment. ADA disabilities are much more frequent. You come across them much more often than you would religious accommodations. It's interesting because in this vaccine mandate world, there's been a switch. So for the first time, we're seeing a lot more religious accommodation exemptions than we are ADA disability exemptions, probably because of the controversy that goes along with the vaccines. There's a lot of folks out there who are associating it with strongly held beliefs, which is difficult to always evaluate whether it's a religious belief or is it a personal belief. I'll talk a little bit about that on the next slide. Accommodations for ADA is a lot more straightforward. Generally, what I recommend is that you just get a doctor's note. Get a doctor's note that says that there's a medical reason for why this employee cannot get the vaccination. Often, a great example is going to be they are allergic to the vaccine. If an employee is allergic to the vaccine or is likely to have an adverse reaction to the vaccine, they probably should not be getting it. And so that is a great example of what a doctor might submit a note and the employee should get an accommodation. Whenever you're evaluating whether to grant an accommodation, and this is the same in the COVID vaccine world as it is in the regular workplace world. Suppose you have an employee who has really poor eyesight and so needs a bigger screen. That might be an example of, you have to evaluate, first of all, did they have a disability? Are you able to provide a reasonable accommodation to that disability, i.e. a bigger screen, and what's the undue burden to the company? So ultimately the question is going to be, does providing this individual with an accommodation create an undue hardship and undue burden on the company? That can be a significant difficulty, it can be a monetary expense, or it can be an inconvenience to coworkers. But these are always going to be the same question, whether you're evaluating an accommodation in the workplace just generally or in the COVID space. So when you are evaluating whether you can grant an accommodation to someone from getting a vaccine, the question is going to be, can you find an accommodation and does it create an undue burden? And in the COVID context, generally you're going to be asking, can this employee come to the work site safely if they're unvaccinated? Are they working remotely? If an employee is working remotely, chances are that granting them an accommodation would not be an undue burden because they're not, coming to the work site. Or maybe if they are coming to the work site occasionally, there are some other protocols you can put in place to ensure their safety or the safety of others. It's really important when you're going through these questions to engage in what's referred to as an interactive process. Again, this applies generally as well in the COVID vaccine space. You need to talk to the individual and evaluate what type of accommodation they need and whether there are alternatives that you might be able to offer that aren't necessarily as burdensome. This is sort of part of the give and take conversation. In the COVID space, some examples of accommodation would be providing PPE, altering work times or assignments to allow the employee to be in the office when it's less crowded, telework arrangements, testing. These are sort of just a sample, but ultimately anything you can think of that would kind of qualify as a reasonable accommodation. And remember, just because an employee asks for it does not mean that you are obligated to provide it. You have to engage in that interactive process. It's a similar sort of evaluation when it comes to evaluating sincerely held religious beliefs. Generally, Title VII requires companies to reasonably accommodate an employee's sincerely held belief. There is a presumption that employees' belief is sincere unless you have objective reason to question that belief. Some examples of what might be an objective reason to question the employee's belief would, perhaps you've heard them talking about how their political viewpoints, not religious, but they've been very vocal about how they are against President Biden, or this is unconstitutional. Comments like that might give you an objective reason to believe that the employee's belief is not religious, but is political or personal. This is really going to be a case-by-case evaluation. For government contractors, because there was the vaccine mandate, it's a little bit more careful or important that you get this right as it relates to really evaluating whether employees do have a sincerely held religious belief. It's fairly typical for employees to voice non-theistic beliefs. Just because it's non-theistic does not necessarily mean it's not religious. This is one of those, I mentioned that the case law out there has not been well developed just because there haven't been a lot of examples of it. But generally, you're going to want to make sure that you are taking a close look and really making sure that you're giving employees an accommodation if they need it, and if it doesn't create an undue burden. Again, that interactive process is really important. I will mention that when you're evaluating sincerely held religious beliefs, technically the threshold for whether something is an undue burden is much lower. And so technically you could have a situation where you would grant a reasonable accommodation for an ADA reason, but not grant it for a religious or sincerely held religious belief because of that difference in the threshold. Okay. Let's talk really quickly about state laws. I know that we're running up against the hour. So generally, as I mentioned, if you have a federal law, that preempts state law under the supremacy clause of the Constitution. There have been states out there who have questioned whether that preemption applies. Montana is a great example. Montana came out and issued a statement that basically said, our state law preempts the federal law. I am fairly certain that their statement would be found to be unenforceable if it went before a court. But in the meantime, probably best not to be the test case for that. And so there are a few states that have sort of mimicked Montana's approach. Montana is one of the most severe. Montana prohibits companies from even asking for a vaccine card. If you're in Montana, the state law there says you can't even ask for people's vaccine standards. You can't discriminate against them based on their vaccine standard. You can't ask about their vaccine cards. Just leave it alone, don't talk about it. Most other states have not taken such a hard line. For example, in Florida, they do not prohibit you from having a vaccine mandate. They just require a really, really broad, run a train through it exemption. And their exemption is basically you need to be able to voice some opposition or be willing to wear a mask or get a test. Anything that basically could be used as an alternative to the test is required to give as an accommodation in Florida. So essentially you can't have a mandate, but they've sort of found a unique way to approach it. Texas, same issue. They require accommodations for personal conscience. So if you have a personal belief, a company in Texas is not allowed to require you to get a vaccine. Other states that have joined recently have been Alabama, Arkansas, Iowa, Kansas, North Dakota, Tennessee, Utah, and West Virginia. If you operate in these states, really make sure that you understand the local law, because you should, for the time being, not implement a vaccine mandate in those states, or make sure that you comply with the limitations that they place on those mandates. Tennessee is also pretty strict when it comes to whether you can ask folks about their vaccine mandates. I will mention, though, that Tennessee had an exemption in there for federal contractors. They understood that the Biden administration had issued Executive Order 14042, so they created basically a way that companies could seek a waiver from that Tennessee law, but they walked that back as soon as the courts came out with the stay on the executive order.
Fair.
I mentioned that they're,
Fair.
Sorry, go ahead.
Yeah, just a quick question on the state law piece, because I know that we have at least a couple of members, as an example, that they're based here in Maryland, but they're doing work and have like another office, say in West Virginia. So I guess does that West Virginia office, as an example, still need to follow, obviously, I guess the West Virginia laws, even though it's a Maryland headquartered company, just as an example, because I know that.
Thank you. I meant to mention that. Yeah. And so I really appreciate you bringing that up, because I know I'm talking to, folks who are based in Maryland. But the way
But just the other thing is, I also know, as I see Texas, we've got folks doing business in Texas, because that's another big cyber hotspot as well, and Georgia.
Right. So it's going to come down to where your employees are working. And this is actually really important in that, a lot of folks have gone home during the pandemic. They're working remotely. You might have someone who's working in California just because they said, hey, I'm not going into the office anymore. Do you mind if I work out of my parents' house in California or Texas or West Virginia? The important rule when this is 99% of the time in employment law, is where the employee is performing the work. So if you have employees working in Texas, even though your headquarters is in Maryland, those Texas laws are still going to apply. So yeah, it's important to keep track of wherever your employees are based or wherever they're working. That's the law that applies. And it can get really complicated when you've got employees who travel or employees who are working somewhere temporarily. There is a little bit more nuance, but as a general rule of thumb, the rule is wherever they're performing the work, that is the requirement that applies. This also comes up in the Service Contract Act world. If you're familiar with the Service Contract Act, it requires compliance with prevailing wage laws, and generally it's going to be the locality of the work location where the employee is performing the work. So you also have a few examples of not states, but localities or cities where they have implemented legislation to the opposite effect. So they're requiring employers to ask for vaccine mandates. It should not come as a surprise that places like New York City and Santa Clara, California have implemented requirements to this effect. And I see your hand has raised, Leonardo.
Yeah, I didn't know if you were, I wanted to bring up a question that was raised in the chat. And it says, as a federal contract working in Texas and Florida, will the federal government accept her approved religious exemptions that don't necessarily meet the federal exemption requirements?
Yeah, that's another great question. So we have not seen the federal government acknowledge that these state requirements in any way loosen the restrictions on the federal contractor mandate. So in other words, the federal government has taking out of the equation for the time being the stay. The federal government has basically said there are only two exemptions to this vaccine mandate for federal contractors: the ADA exemption and the Title VII sincerely held religious belief. The government does not acknowledge any of these other state exemptions. Eventually, assuming that the EO goes into effect again, I would imagine there will be a court case on this that will confirm once and for all, whether it's the state law or the federal law. My money would be behind the federal law, but we haven't gotten to that step yet. If you're operating in one of those states and the stay is lifted, you want to be careful about how you grant exemptions. You want to make sure that you have a good reason for granting an exemption. Chances are agencies are not supposed to be asking for the basis for your exemptions. And so maybe they'll never know the difference, but it is a risk. It is something that ultimately could put you in conflict with the requirement in your contract. And that's the end of my, if anyone has additional questions, I'd be happy to, I know there was a lot of material, but I'd be happy to go over any questions. I know that we have a little bit more time, I think.
I guess if there are no questions, Sarah, I want to thank you for sharing the information that you provided with us this morning. Certainly, you know, a lot of moving parts here, and I think constant musical chairs. As you were talking, I was just thinking it's a lot to certainly stay on top of. But for those of you in attendance, we will make sure that we share a copy of the slide deck. Well, I guess, Sarah, is that okay?
Oh, yeah, that's fine.
Yeah, I just want to make sure. But yeah, but we'll share a copy of the slide deck, so you'll have it as reference, and certainly you have Sarah's information should you want to follow back up with her on anything that might be specific to your company, your situation that you didn't want to maybe put out in the public and in the open. But also want to just remind you again of upcoming chamber and GovConnects programs again on 2/10, when we'll have with us Aberdeen Proving Ground. And that's also going to be where you can come in person or participate virtually. So depending on where you're located and what your situation is, we will have a virtual option. And so details are on the Chamber's website. Also, the labor force discussion on the 9th. And then again, the state of business address with County Executive Ball on the 23rd. Of course, there'll be other programs throughout the course of February. Actually, our next scale up, we're in the process of finalizing, which should be actually on the, need to print the latest schedule. Taylor, what is our new scale up date? I think, is it February 24th, perhaps?
I believe so, but let me double check. I know with everything constantly changing that our January and February calendars.
24th.
Yeah, so February 20th.
I have the 24th down.
Yep,
Thank you.
that's correct.
So we'll be February 24th, and we're going to have Red Team Consulting, who will be leading our discussion and basically talking about common mistakes and other best practices as it relates to capture management and proposals and ultimate business development. And so we know that everyone is always out ultimately trying to get the next contract and so forth. So we're going to have a great conversation there. And so again, stay tuned and thank you all and have a great rest of your day and continue to be safe.